Good morning. I hope you had a good and healthy sleep last night. And we still have a fairly substantive list of non-governmental organizations that wish to address us. There is also in the afternoon, but not a formal session like this, but members of both committees actually will be available, and it's easier to address us individually because it is still before we are starting with our concluding observations. So if there's anything you would still, after also the review meetings of today, would like to tell us, where you feel we don't have enough information or there was something said where you disagree, you can still individually address us. Perhaps to also remember who is responsible for what, because we have an internal distribution of labor. For the first drafts of the concluding observations, Nisuke Ando is responsible for Articles 1 to 5, 26 and 27. Myself for Article 6 up to 13. And then Jerome Cohen, 14, 15, 16. And Asma Jahangir, 17 to 21. Asma feels sick in the moment, so she apologizes. She will try to be back at 10 o'clock, but now she's still sleeping. And Shanthi Dairiam for 22 to 25. So if you have something specific, let's say on freedom of association, then you come to Shanthi, and the same is with respect to indigenous peoples, Article 127 to Mr. Ando. All right, the first NGO on my list from yesterday is the Taiwan Alliance for Advancement of Youth Rights and Welfare, and it relates to Article 8. Is a representative here? TARVZE, Advancement of Youth Rights and Welfare. Then I have the Taiwan Association for Human Rights in relation to Article 9. That's according to my list, yeah, Article 9. But of course, if you have I have the Taiwan Association for Human Rights also on Article 13. So you can use your statement and combine both.
Thank you very much. We are Taiwan Association for Human Rights. I want to make statements on ICCPR 17 and ICCPR 21 and 22. We are Taiwan Association for Human Rights when we want to make statements on ICCPR 17 and 21 and 22. We know that in ICCPR 21 and 22, it relates to the freedom of association. This is fundamental rights, especially in a democratic society. This is the guarantee that people have the right to participate in public affairs, so that any groups can voice their opinions. This is a very important protection of a basic human right. However, in the past, there was authoritarian regime. So these fundamental rights was quite limited in the past, especially when it comes to the act of assembly and the act of people's organization. Now, the Act of Association in Taiwan at this point requires people to register and to be reviewed first. And competent authorities, such as the Agency of Police, has an arbitrary discretion. And these agencies have the right to impose penal punishments on the people who are engaged in assembly, and this is not compliant with people's fundamental rights. And in the Act, it stipulates that people who want to engage in protest or association or assembly has to reach the threshold of 30 people, which is quite high. So we can see some explanations on this issue in state reports and shadow reports, and we can see that the Act of Association in Taiwan right now is in violation of Article 21 under ICCPR. So we suggest the committee to raise some questions toward government representatives. For example, the government has admitted that these acts of assembly or association are in violation of the two covenants, but there's no revision of the act, and therefore people are forced to leave. And we also want the government to set a very clear timetable for the revision of this act. Or before that happens, the government should provide channels of for remedies. And another issue is, if the government is in violation of two covenants, there should be an accountability system. So these are the several issues that we want to raise regarding ICCPR 21 and 22. Now, I want to talk about ICCPR 17. The Personal Information Protection Act, PIPA, was passed in 2011 and came into force in 2012, well, partially came into effect, and we can see that some agencies abuse this power. And the Ministry of Justice, even though they have received shadow reports, they refuse to make these shadow reports public in the name of protecting personal information. And there's another center that collects people's credits information, which is in violation of personal information. And the Universal Health Insurance also collects people's information without the consent, and the government even release these personal data to the academics in the name of research. But this is done without obtaining a consent of the people first. So even though this data is anonymous, these huge number of entries of data is stored in many different databases, and through some databases linking, it is still possible that the identity of this person will be discovered. So we think there is a need for the supervision body for the center that collects people's credit information. And there should be an exit mechanism for people who don't want their data to be used in academic research, who don't want their medical data to be used in academic research.
Thank you very much for both statements. The next organization is the Taipei Association for the Promotion of Women's Rights. Taipei Association for the Promotion of Women's Rights. Is anybody here? Then I have the Awakening Foundation. I don't know whether that's the list of issues number 10, etc. If nobody is here, the Taiwan International Workers Association. The Taiwan Friends of Tibet. The Taiwan Criminal Law Association for Financial Study. Yes, because we were not, but we are almost through yesterday, so then Union of Excluded Immigrants and Unwanted Citizens, Catholic Scalabrini International Migration Network Taiwan, and Taiwan International Family Association. That was a joint statement. Also on Article 12, Taiwan Tongsi Hotline Association. Taiwan Alliance for Migrants Living with HIV.
Good morning. We'd like to address the list of issue number 47 regarding the exclusion and limitation of movement for the foreigners living with HIV/AIDS. Our recommendations for the government would be to abolish the policy which restricts the entry and short-term stay of people living with HIV, and second, to abolish the law which required that people who were tested positive for HIV to be deported from this country. And we also would like to recommend that the committees reject the government's possible replies regarding, first, they might say that this is, they are doing this for the purpose of public health, but we are claiming that this policy would work on the country just to destroy the people's opportunity to get treatment, because we know that some people would, because they are not allowed proper treatment, they will buy counterfeit medicine or even share the same dosage of medicine with other HIV positive people. So that would impose the risk of drug resistance and therefore damage rather than protect public health. And the second, we like to say that the government cannot do this because of financial burden, because number one, those who are tested positive for HIV do not necessarily need treatment. And the second is that as far as migrant workers are concerned, because of the generally better health status of them and the underutilization of health care, they are in effect financially subsidizing the national health insurance because they pay as much as the health insurance fee and they are underutilizing it. So there is no reason, as far as migrant workers are concerned, to use financial burden as the reason for not providing the treatment. So we say that there are several laws that need to be revised regarding immigration, regarding AIDS management, and the employment services law, which concerns the management of migrant workers. Thank you.
Perfect. Thank you very much. Please. Law Association for Financial Study.
Yes, we'd like to combine together to speak on their behalf with our NGO.
It's on Article 12, no?
Yeah, Article 12.
Yes. All right.
Okay. So we will combine our issue on Article 12 and Article 18. Thank you for the committee members today. We'd like to focus on the subject concerning Taiwan's government's violation on the Article 12, Article 18 of the ICCPR, as it violates people's freedom of religion and also the ban on the traveling through unlawful prosecution and unjustified taxation practice. In 1996, we want to bring on the real case, Taijimen. Taijimen was targeted during the government's clampdown on the illegitimate religious group in 1996. However, Taijimen is a traditional menpai of Qigong martial arts and heart cultivation group based on the belief of Taoism and lawfully registered as a civil organization of Qigong martial arts and Taoism with the government. In 1996, prosecutor Ho Kwan-ren falsely claimed Taijimen was an illegitimate religious group and violated the principle of private investigation and spread rumors on the media to form a biased opinion against Taijimen and search all the civilian residents and different branches of Taijimen Academy without any legal ground. They unlawfully seized and froze all the assets of Taijimen leaders. For 17 years, this was still held by the taxation agency, and they ordered local government to disband Taijimen Academy. Moreover, he fabricated a fictitious income of USD 106 million on the leader of Taijimen, despite the real balance of the income is only USD 20,000 on his bill of indictment. And moreover, he gave this bill indictment to the tax authorization to issue the tax penalty. But in 2007, after 10 years of 3-court trial, Taijimen was found not guilty, no invasion of the tax code, after 10 years and 7 months. And the monetary gift from the Taijimen members to their leader was determined and ruled by the court as a tax-exempt gift under the law and the tax code. And more, the Control Yan, the government agent, Control Yan initiated the report on the Taijimen case, outlined the prosecutor's 8 major flaws in his handling of Taijimen criminal case, and asking the Ministry of Justice to impose a disciplinary action against the prosecutor Hall. But this same case has been transferred to the tax agency, at the same time using the unlawful bill of indictment to impose the tax and the penalty to Taijimen. And but even though the data of the prosecutor's bill of indictment were invalidated by the court, the tax continued for 17 years, even till today. And with their assets all freezed by the government, tax agency, they ordered a prohibitory injunction on the leader and also issue a travel ban against the Zhang Menren, the leader of Taijimen, that he was not able to return to Taiwan to unite with his family for 17 years. And Control Yan initiated an investigation report and outlined 7 violations of law by the tax agency. And after the leader of Taijimen and his wife seek administrative remedy, the tax agency refused his right to reveal the evidence related to his case, so he's not given a fair trial. Even though the Taijimen leader has provided a sufficient amount for the collateral to the tax agency, still the travel ban is still imposed on him, and thousands of Taijimen deeds, more than 10,000 Taijimen deeds, today was not able to see their leader. And he was not able to come home to reunite and to preach in Taiwan. The tax agency intentionally misinterpreted tax codes and disobeyed the dual process of law and distorted the nature of religious contribution from the deeds to his leader, and forced Taijimen to change its way of operation and clearly violate the people's freedom of religion under the Article 18. We really asking the government agencies to respect the diverse way of operation of different religious groups. They should respect people's freedom of religion, right to believe, right to expression, and should not use any unlawful judicial or taxation means to change the religious practice and respect people's right to believe. And the travel ban should not be used without the reservation of judge to ban citizens' right to travel and return to his homeland. Thank you.
Thank you very much, also for staying within the time limit. Now we come to Article 14, Judicial Reform Foundation. Anybody here from the Judicial Reform Foundation? The second is the Chinese Association for Human Rights on Article 14. The Association for Taiwan Indigenous Peoples Policies. Also on Article 14.
Good morning. I speak on behalf of ATIPP to make statements regarding Article 1 and Article 14 and Article 27. We know that this year, January this year, the Judicial Yuan decided that 9 indigenous peoples special courts have been set up at 9 district courts. I think you are aware of that, but I have a few questions to raise here. First of all, the indigenous peoples special courts do not handle administrative litigation. However, we know that most pending cases related to the indigenous peoples are administrative litigation cases. This is because the indigenous peoples practice their traditions in their daily life and were brought to court because of that. Secondly, speaking of the indigenous people specialized in legal and judicial work, there is a severe shortage. Yesterday, you heard that the government representatives told you training was provided to the would-be prosecutors and judges. However, there are only 32 hours of training. Not to mention, we have over 20 groups of indigenous peoples on this island. So it's very hard for us to expect this special course to be really professional. Thirdly, one of the major issues is how to integrate the indigenous customs and traditions into current legal and judicial system. There is a very well-known incident of the Zhou chief and honey. The chief followed the Zhou people's traditional custom to exercise his inherent right to deal with incidents which took place in Zhou's traditional territory. However, the court sentenced him and convicted him guilty of robbery. So, all in all, with only 32 hours of training for judges, I don't think they will have sufficient understanding of the traditions and customs of the indigenous peoples. Finally, I would like to talk about the language problem. Even though the existing law says that language services or interpretation services should be provided in the court, however, in practice, this is not the case. I think this has violated the Article 14 of the ICCPR. So our recommendations: first, the indigenous peoples special courts should also handle administrative cases. Secondly, when it comes to the selection of judicial personnel, more training must be provided so that all these judicial personnel have sufficient understanding of the indigenous people's culture and traditions. Thirdly, the government should proactively conduct the research on indigenous people's legal theory so that indigenous peoples can enjoy their right to fair trials. Fourthly, the government should increase the number of professional court interpreters. They should also receive legal training too. That's all from me, and from page 58 in the shadow report, you will see more statements from us. Thank you.
The next one would be the UN NGO Association of World Citizens in Taiwan, but I think you have made the statement already. Then Association of Taiwan Journalists. That's you. Article 19, I guess. And I also have here campaign for media reform, Taiwan Alliance for the Advancement of Youth Rights and Welfare, Citizen Congress Watch. Are you speaking on
yes, because the other people haven't come, so I'll take it over. Very briefly, I'd just like to emphasize.
Actually, the Congress Watch does have a representative to make statements later.
Just to first re-emphasize a couple of issues that were brought up, one by Jerry Cohen regarding to what is going to be done with regards to the China Times Group's proposed acquisition of the Next Media in the absence of the passage of a robust anti-monopoly law. So our suggestion is that the government should refer simply to Article 19 and General Comment Number 34, Paragraph 40, that the overriding public interest should be to prevent the monopolization or the negative impact on press freedom of monopolization, and so therefore should at least delay review of this acquisition until a robust anti-monopoly law is passed, or simply reject it outright. Secondly, there are many problems with the proposed anti-monopoly law that was drafted and published last week by the National Communications Commission. We addressed some of these issues in our written submission, but one issue which I think again needs to be emphasized is this question of the right of reply, which would be out of, in a sense, a violation of the issue of proportionality, that the question of how people can who are perhaps victims of incorrect reports or how they can address this issue does not necessarily mean a mandatory legal right of reply with civil penalties, but can be handled through perhaps appointments of ombudsman or of the actions of the ethics committee. But to require a right of reply would very clearly impact on editorial rights and also in a sense impose a new type of self-censorship. The other issue which hasn't been talked about too much is the question of the public television system, and there was going to be one person who's going to address that. This is discussed in the parallel report in a certain amount of depth, but the situation remains deadlocked. Very recently there was another attempt to nominate and pass new directors to the and supervisors to the public television board, but because again of political disputes between members nominated by the Kuomintang and other parties and by the DP and by the Democratic Progressive Party for different reasons, this board still hasn't been created. Now the KMT government is proposing revisions to the Public Television Organization Act which would not necessarily make this situation any better. For example, now the requirement is that the nominees of the for board directors and supervisors need to have 3/4 support of the review committee, which is nominated by the various caucuses of the legislature. There are proposals by the government to reduce that to simple majority. What that would do effectively would be to further expose public television to direct political control by whatever party is the majority legislative party, instead of the current system, which obviously has very many problems, but does provide some, at least ideally should provide some firewall for short-term political impacts. In any case, the way in which this issue has been handled is the background is clearly of the ruling party wanting to take control over public television as well as regain control over various media outlets such as the Central News Agency and Radio Television Taiwan, which were before the KMT came back into power, were independent state enterprises with independent editorial policies. So anyway, there's still quite a few issues that need to be discussed. Thank you.
Thank you very much. And you indicated that somebody else would talk about television?
No,
No, you did. Okay. All right. Thank you very much. Then we have the Taiwan Youth Think Tank. I have them on Article 9 and 21. Then Nylon Cheng Foundation on Article 19. The Taiwan Alliance for Victims of Urban Renewal on Article 21. Please.
各位委员好，
Good morning. I am Peng Long San, the chairperson of the Taiwan Alliance for the Victims of Urban Renewal. I would like to bring your attention to what the reality is versus the state report. According to Article 19.2 and Article 21, Article 22, people have the right of expression and the right to peaceful assembly and the freedom of association. However, in the state reports, it is said that 14 existing laws actually would pose restrictions on freedom of expression. And I indeed have been brought to the court because I did not want to take part in an urban renewal project, and because I serve as the chairperson of this alliance, I was also subpoenaed on the charge of public insult. Moreover, in the state report, it says that according to the existing Act of Assembly and the People's Organization Act, people's right and freedom for association has been excessively restricted. I think that is correct. For example, the name of my association has been criticized by local government and central government as inappropriate because the title of my association would mislead people to believe that urban renewal would result in victims. The state report also says that the two covenants should take precedence over domestic law. Indeed, we agree on that point, but the government is not doing what it says. Last February, when we try to educate the public about the process of forceful demolition of some housing units, the Ministry of the Interior actually wrote us a letter demanding us to remove such content on our website within 7 days. After we leaked the news to the media, the Ministry of the Interior said that particular letter was not signed by the minister. There was no signature of the minister on that letter, so it is not a valid official document. As a result, no investigation took place. Again, according to Article 9, people should have the right to personal freedom and security. There should be no unlawful arrest and detention. The matter of the fact is, when we go to the street, many young students were arrested and detained by police. For example, in the Wenlingyuan incident, where the houses were demolished by the local government without the full consent of local residents, a lot of people went to the site to support these residents. However, they were arrested by more than 1,000 policemen without due process of law. According to Article 17, people have the right to privacy, and the state reports agrees on with that, and also says that there are many provisions in existing law to safeguard such rights. However, we as citizens in this country have been monitored and put under surveillance by the government in our daily life. So I think the government is not doing what it says it would do or should do in the state report, despite the fact that the government has signed and ratified the covenants and finished the state reports. Yet, when there's a violation of the provisions in the two covenants, no one in the public sector has been brought to justice or being punished. So we demand that all provisions and laws such as the Act of Assembly, the Act of Association, the People's Organization Act must be removed.
Now we come to the last three articles, 23, 24, and 25. The Taiwan Alliance to promote civil partnership rights. Please, you have the floor.
Good morning. My statement is issued on behalf of the Taiwan Alliance to promote civil partnership rights and Taiwan Tongzhi Hotline Association with regard of Article 23 of ICCPR regarding family rights. Okay, first of all, I want to point out that according to our survey, there are many LGBT families and unmarried cohabit couples in our society. You can find the result of our survey in my statement and our shadow report as well. To sum up, the survey found that more than half of the respondents have cohabitated experience, and the longest cohabitation was 23 years for lesbians, 15 years for gay men, and 11 years for heterosexual couples. Okay, secondly, I would like to give some concrete examples to explain, without legal status, what kind of obstacles and unequal treatment those families could face too. As you know, same-sex partners are not allowed for co-adoption, and even denied the right to adopt his or her partner's child. A recent ruling by the German Federal Constitutional Court found that such legal discrimination violates the principle of equality. However, not only do the Taiwan courts continue to deny adoption rights to same-sex couples, in 2007, a lesbian tried to apply to adopt her sister's daughter, and it was rejected by the Taoyuan District Court only because of her sexual orientation. Okay, in another case, a gay couple, they raised a child together for several years, and then they separated. Following separation, the biological father denied visitation rights to her former partner, and when the latter attempted to visit their child, he was charged with abduction. Also, in another case, a woman who had cohabited with another woman for many years transferred assets to her partner prior to her death. However, members of the deceased family subsequently demand the return of those assets. Okay, so there are still a lot of more cases like this. So we strongly recommend that the government should enact laws to protect the rights of LGBT partners and diverse families without delay, because only through legal protection can we help to reduce and eliminate social prejudice. Actually, I think our demands are very simple. Everyone deserves the freedom to love, and there should be equality for all kinds of families. Thank you.
Thank you very much. The Taiwan Gender Equity Education Association, please.
Good morning. I represent Taiwan Gender Equity Education Association, and I'm going to make some comments of the Article 23, my report, especially on the issue of LGBT students' rights, stands for lesbian, gay, bisexual, and transgender, and the inadequacy of LGBT education in Taiwan right now. The background of the dispute of LGBT education and our suggestions are in the handout, so I'm going to talk more about the cases. And so I'm going to talk in Mandarin. 我想要说的是，在台湾，因为性别气质，或者是因为性倾向不同，
there are young students who are bullied because of their sexual orientation or gender temperament, because their non-traditional gender temperaments lead to some prejudice. And in the year of 2000, there was one of this kind of case. There was one student who was found dead in a school toilet, and nobody knew why. Maybe this student was bullied or pushed over. Nobody knew the reason. But again, in 2011, a 14-year-old boy jumped from his family's apartment building from a really high floor because his sexual orientation or gender temperament was not accepted by the family members. And there are some young boys who are not willing to go to the bathroom when they're in school because other boys were bullying them, like pulling their pants off and asking them, "Are you really boys?" So there is quite a few of cases of school bullying on students with different gender temperaments or sexual orientation. Some of them even committed suicide. In 2011, 2 girls at the age of 16 or 17 committed suicide because their relationship was not accepted by people around them. There are more cases like this. So what we want to suggest is that the MOE should move beyond paperwork and should not surrender to the opposition from the religious groups. And We hope the friendly campus policy can be included in the national curriculum guidelines, and teachers should educate students to be more acceptive, and the government should be more assertive and provide more services to LGBT students. Schools should take the initiative because schools should serve all students, not only heterosexual students, but all the students.
We have one last short intervention, but you were speaking already on the of the Taipei Association for the Promotion of Women's Rights. Yeah. I don't know.
We didn't talk either.
Still associations left in relation to Article 23, 1, 24 and 25. They all fall under Shanthi's responsibility. I just asked her, so she would also be available, and I am as well, and I hope others also during the lunchtime. We have a short lunch here. I was yesterday approached by a group of indigenous people's representatives. So that is one possibility, because these rights we will also take up in the afternoon. So there's still time enough at lunchtime. And as I have said before, between 5 and 7, we are all individually available for further information that you would like to provide to us. But we have to start now in 1 minute with the Governmental Review Committee. So I hope for your understanding that we have to finish now the NGO briefing. But as I said, there's ample time for approaching us individually at lunchtime and in the late afternoon. So you still wanted to say?
Oh, okay.
Maybe can you provide another 10 minutes?
It's not on.
Because this session starts till 10 minutes later, so should we have 10 minutes more to 10:10? I want to talk about Article 25. May I speak on 25? May I have 5 minutes?
To come in, I think we can't just go until they. So the meeting actually should start at 10. So we were now it's 10 o'clock sharp. And I think we have to allow the representatives of the government to.
But if I.
Article 25 will be dealt with only in the afternoon, so there's plenty of time to talk to Shanthi or also to others about Article 25.
But will translation be provided at those times? That would be my concern, because I won't be able to speak English directly with the committee members. If during lunchtime translation can be provided, I am willing to do that. But if not, may I use 5 minutes right now to discuss this article, because this session started 10 minutes later, so I think it's okay if we delay another 10 minutes.
You're speaking on behalf of which organization?
I am here on behalf of Congress Watch. And my statement number is from 11 to 14. And I think the parliament should go through some reforms. I think there are 3 problems at the parliament. The first is the information non-disclosure, and the second is citizen participation. The media usually broadcast Congress in a way showing that there are only conflicts in the parliament, so we can't really see the reality. And when media want to enter the parliament, sometimes we are rejected. So, but we think whether we're allowed into the parliament should depend on whether there's a need for the facts at the parliament to be discovered. And currently, we don't have a hearing system to determine issues related to the parliament. So I think in the future, we should open opportunities to have media to sit in galleries to observe the parliament. And I also want to show you this picture. This is a standing committee. This is the second reading stage of the legislation, but only officials and legislators can be admitted. And 2 months ago, the opposition party invited a citizen to come to the room, but the ruling party opposed to that. And the very next day, the Legislative Yuan was reviewing an act for the people of disabilities. And the ruling party, right after the meeting started, suggested all the citizens who are non-government officials, who are non-legislators, to be asked to leave the room. And if you ask our government officials, they will say that, well, citizens can come in, but they can only enter the committee of the hall. And you can't apply to enter this place individually. You have to submit your application in the name of a group and 3 days before the meeting takes place. So I think these are just some excuses by the Legislative Yuan. And we know that 30 years ago, anyone with an ID card can enter the gallery and to observe the parliament. So we moved from authoritarian to democracy, but it seems that it is not happening like that at our Legislative Yuan. And in the parliament, another concern of ours is that only the government officials have the voice, have the opportunity to speak, but we think citizens should also have the right to either observing the Congress or to speaking. I think it is a very important way to educate people about democracy. Through this process, the process of participation, the citizen will be able to know better as to how to be more engaged. So I hope in the concluding observations, you'll be able to include some of your suggestions to ask Congress to admit the citizens to enter standing committees and allow the citizens to speak and to allow media to come to the room. And we also ask the Congress to set up a TV channel or a website channel to broadcast the meetings. Oh, hi. We've been waiting so long for this opportunity, and I want to discuss Article 8, which is number 35 in LOI. I want to discuss the issue of student apprentice. And the student apprentice system has been in Taiwan for 30 years, and many of them are economically disadvantaged students. And 90% of these type of projects are conducted by private schools. And these student apprentices are students and laborers at the same time, and many of them are from low-income families. So we think they should be protected by law even more. But the labor agencies has not provided enough protection for these student apprentices yet. Many companies such as HTC owns more than 4,500 employees at the assembly lines, and more than 1,000 of them are student apprentices, and they have to take night shift. Based on our visitation experience, we visit HTC and 10 students who work at HTC, and their punch card shows that they work overtime at least 10 to 12 days every month. Sometimes they work overtime for more than 20 or 40 hours. Based on an online survey, we found that 61% of student apprentices have to overwork, and many of them overwork by 10 to 12 hours on a daily basis. So it is beyond the regular labor working hours, which is 8 hours a day. So it is our concern that these student apprentices have become slave laborers. And the control yuan has pointed out that the guideline on student apprentice is not enough. So many enterprises or industries are taking advantage of the student apprentice. The legislative yuan finally passed the act to protect student apprentice, but in the national reports we only see the MOE include the articles, the provisions, without actually explaining if the new act is helpful to protecting the rights of student apprentices. So we suggest the government should establish a complaint channel so that the family members, the parents, and the student apprentices can submit their complaints. And we need a review panel to decide which industries or what enterprises are allowed to use student apprentices. Thank you very much.
The information also in writing. So thank you. This closes the NGO meeting, but as I said, possibilities to talk at lunch and also in the later afternoon. Thank you very much. I hope that I will also see you during the governmental meeting.
不好意思，麻烦各位朋友尽速离开会场，我们还要进行下一场的场部，谢谢大家配合。